Thank you. For the record, Darryl Perry, CEO of Lobby LLC. And I want to try answering a couple of questions that have been asked. There was a question about line 19 where it said may result and how that conflicted with previous testimony to where the statute says that, you know, by signing you're acknowledging that you are subject. So if you go up to lines 13 and 14, it says by using cannabis, the qualifying patient is subject to the denial of rights and privileges by federal agencies, and then goes on. Line 19 is acknowledging that a certain thing is a Class B felony and may result in the revocation of the registry card. So if you get convicted of a certain thing, you might wind up losing your therapeutic cannabis card, not you might wind up losing your right to bear arms, the ability to drive certain vehicles for compensation. Representative Knert, you asked the question about does this go far enough, and I don't think that it does. I'll explain why momentarily, but let me sort of try to simplify this a little bit because I think a lot of people are trying to make this more complex than it is. And Representative Edwards, you hit on the head of the nail there with the words or condition. But let's look at the language that is being stricken. Significantly interferes with the daily activities as documented by the patient's provider. There are certain things, arthritis being one of them. Arthritis, not currently a condition that's listed, but would be under this or condition. People with arthritis don't necessarily have daily issues. Some days are worse than others. There are certain medications that doctors prescribe, take as needed. So this would open up a little bit, but now I get into where it doesn't go far enough. Looking at section 126-X:192, where it lists the symptoms that one must have. The one that I particularly have the problem with is the following: severe pain that has not responded to previously prescribed medication or surgical measures. That leads me to read, as someone who is a publisher and editor, that some doctors might say, well, it's not responded to medicine, but before I can prescribe you cannabis, we have to do surgery. So that's where I think it doesn't go far enough, because the wording here could be interpreted by a physician to mean that they have to try surgery if you have pain before they can prescribe you cannabis. I think this is definitely a very good start in the right direction, and I would ultimately love to see the and change to an or at the end of 9(1). That way, if you have a condition or symptoms, but adding the word or condition definitely, again, steps in that right direction. I will agree with, I believe, every previous speaker that lines 10 down need to be stricken, because it does sort of tie the hands of this body of if federal law changes, and I do not want to speculate why I think it was added, although I have a theory of why I think it was added, but I'm not going to speculate because I don't know for certain, and with that I'll attempt to answer any questions.
Questions? Representative Clare.
I put in the form of a question, so I'll say, would you believe that I think somehow we are confusing, though, lines 11 through 17 and the words in 19? Because what 19 is referring to, you said if they're guilty of something, it says it clearly. It has to do with diversion. The revocation has to do with diversion. It does not have anything to do with lines 11 through 17. They're totally different phenomena. So I don't think we have to keep being stuck on this may result in. Would you believe that?
I agree.
Okay.
Other questions, follow-up?
Follow-up. Would you believe I also do agree with you that as a retired surgeon, the idea that I would have to submit somebody to surgery in order for them to have a less invasive option for their pain relief would be ludicrous.
I agree.
Further questions? Seeing none, thank you very much, sir.